Transfer. All right, good afternoon, everyone. For our meeting of the Automotive Right to Repair Working Group. I'm Chris Taub. I'm the Chief Deputy for the Maine Attorney General's Office. Why don't we, as we do every meeting, we'll just go around and introduce ourselves. Jack, why don't we start with you?
Jack Quirk Auto Group.
I'm
sorry, Jack Quirk Auto Group.
Jeff Groves here for the aftermarket retailers and distributors.
Thanks, me.
Yep.
Elizabeth Frazier here, partner Pierce Atwood here on behalf of the Alliance for Automotive Innovation, which are the manufacturers.
And then online, Tim.
Tim Winkler, VIP Tires and Service.
Brian.
Brian Boggs from Tesla, representing auto manufacturers.
Eric.
Eric Luftig from Dorman Products, representing aftermarket parts.
And Michael.
Michael Cabetta, ACLU of Maine, representing, I believe, consumers.
And welcome to the working group, Michael. Megan, I know is stepping away, so we're glad to have you in her place. So I think the agenda for today is a combination of a discussion among the working group members and then followed by a public hearing. And just to sort of bring everyone up to speed on, I think, where we are. Christina and I had circulated a couple weeks ago revised drafts of both the report to the legislature and our proposed revisions to the statute. And the draft that we had circulated was revised based on some discussions that we had during our last meeting. And then we also invited anyone who wanted to propose additions to the report to make those submissions to us. And then so 2 weeks ago, we circulated a revised draft that incorporates basically our discussions at the meeting and also the comments and suggestions that we got from the different working group members. And so what I thought might make sense is to maybe to start with the report. And I think that there might be some issues that people want to discuss regarding the very end of the report, which has sort of recommendations that individual members of the working group are making that aren't necessarily consensus recommendations. So I just kind of want to, and that's the part that's called other recommendations. But so I think there is going to be some discussion about that. But before we get to that, I'm just wondering, for the rest of the report, are there any issues that people saw? Are there any revisions that people want to make? Is there anything that you think we got wrong or that should be added to the report? So let me just throw it open for discussion, whether there's anything in leaving aside the other recommendations part, is there anything in the draft report that people think needs to be worked on?
Chris, this is Tommy Hickey. I just wanted to announce that I'm on. So Tommy Hickey, director of the Maine Automotive Right to Repair Coalition. I think if you can hear, can you guys hear me?
Yeah, we can hear you.
Great. I think as a part of the report, we see individual members having either offered tweaks to the legislation or recommendations. And I think in an effort to be probably the most transparent, I think it would be helpful to have what members are speaking to identify certain amendments versus other members of the group's takes on said amendments. So to say, ACLU recommends X and the following members supported this or were against this, I think would be helpful for the report for when it was submitted to the legislature so folks could see kind of where the stakes were on the ground.
Yeah, thanks, Tommy. And let me just put a pin in that comment, because I think we can get to that when we get to the other recommendations part of the report, because I think that's probably what you're referring to. Just at this point, I just want to focus on the other part of the report, sort of the part of the report that has the consensus recommendations, that has kind of the discussion. I'm just wondering if there, because I think, and I'm hoping, and my fingers are crossed, that we have a pretty good consensus on that part of the report. and that I'm hoping that people are pretty good with where we are. And so I just want to know, leaving aside again the other recommendations part, is there anything in the rest of the report that people had concerns about? I'm not seeing anything. So I think I think we're probably in pretty good shape with at least the part of the report that is the consensus portion of it. But if during our discussion people want to go back and raise a concern, please feel free. So I think then we do need to discuss the portion of the report that's captioned other recommendations. And so just so everyone knows and it's transparent, what Christina and I did was when we at our last meeting, we solicited and asked people if there were recommendations that they wanted to make to be included in the report. We just invited them to send them to Christina and myself. And we got submissions from a few different members. And we decided that we were not going to screen the recommendations, that we weren't going to make a decision about whether or not something should go in the report or not, because we thought that's something that the group should have a discussion about. We did try to sort of wordsmith the recommendations a little bit. I mean, we tried to keep sort of the spirit of everyone's suggestion, but we just tried to make it more concise or just do some wordsmithing here and there. But so basically, whatever we got, we put into the other recommendations portion. If there's something that someone sent us that we didn't put in here, it was our oversight. It wasn't intentional. So please, if you see something that we missed, just let me know. And then what we tried to do is we tried to identify, and I think Tommy, this goes to your point. We tried to identify who was making the different recommendations. I think there were a couple where we didn't, just because we had a sense that there was a lot of people that were agreeable. Like, for example, I think the one about hearing from different stakeholders, even though I think that recommendation sort of was originally suggested by the member representing the ACLU. I think a lot of people on the commission agreed with that, so we just didn't think it made a lot of sense to identify the specific people that were behind that one. But I think for all the other ones, we did try to identify who was making the recommendation. So that was the process. And so let me stop there and now ask folks sort of what they think about that other recommendations part of the report. If there's things that people think should be revised, should come out, should get added, just whatever you think about that section. Yeah, Jeff.
So if I could maybe start in reverse order, kind of looking at the recommendations, I'd first like to comment on the recommendations from the member representing the new motor vehicle dealers. There are several items in that list of items that I felt might be outside of what this group should be accomplishing, and perhaps outside of the spirit of this particular piece of legislation. The first specific comment that I would have is about number 2 and whether or not Gramm-Leach-Bliley should apply to independent repair facilities. Gramm-Leach-Bliley, is a federal law that regulates banks and insurers. And I'm not sure, to be quite candid, after having reviewed Gramm-Leach-Bliley in response to this comment, really understand how that relates to this. This is certainly not involving banking or insurance company regulation. I'm sure that there are certainly parts of that regulation that talk about privacy, and maybe that's what this comment is going to. I'm not sure. But just saying whether or not that bill should apply to independent repair facilities, I think puts an undue burden on them, and I think really is out of bounds. With respect to other comments, and really the rest of the list, 3, 4, 5, and 6, when I read those, it seems that what the attempt is to have some discussion about how we should further regulate small Maine businesses that happen to be independent repairers. And I'm not sure that these items, and I think probably Tim Winkler could speak to this better than I could, but to what extent do independent repair facilities have to be bonded now? To what extent do independent repair facilities have to disclose certain items to customers? Those are things that I don't think exist in terms of the regulation of those businesses now. And it seems like this might be an attempt from the new motor vehicle dealers to add additional regulation where none was contemplated by the underlying regulation. That would be my comment with respect to those items.
All right, so why don't we, and Jeff, I'm not sure if you have comments about other sections of
I
about this,
do.
but it probably makes sense to stop there
Yeah.
and see if other folks want to comment on just the recommendations that were made by the member representing new motor vehicle dealers. Any other comments about those suggested recommendations? Yeah, Elizabeth?
I guess this is more not specific to these recommendations, just more of a general observation on the other recommendations component. I think the fact that they're identified as who they're coming from is important, and I think that's done well here. Others can disagree, but I do agree with your point about the early ones that seemed more general. And I think it's pretty common for whether it's called other recommendations or other considerations, discussion points for these types of reports to include other, substantive issues raised by the working group that were not consensus items. So I do think it's appropriate to have this section, so long as it's clear, and I think it is, and perhaps it could be more clear, but that these are, coming from whom they're coming from, and that they're just inclusions in the report. So I'm certainly comfortable with that layout of it, and that's just all I wanted to add. I don't have anything specific on those provisions.
Okay, yeah, no, thanks. Any other comments on the recommendations from the dealer member?
Chris, just wanted to answer some of
Yeah, Jack.
Jeff's concerns as far as the Graham Leach bill is that talking mostly about right to privacy and how the data is collected and stored, and making sure that if there's a person in the business that is the person you go to if there is a problem. Okay, that's why that was brought up. Bonded. A lot of dealers in Maine are small business people. They really are. They're not. No one's really huge like they are in certain parts of the country. But we're required to carry a bond. And the reason why you do that, if the consumer has a situation where he has a legal right and it should be taken care of, and the business goes out of business, they should be protected. And now that we're collecting data and making sure that this data is protected, number one, and where it's going, I think it's important. Maine has a law that all new automobile dealers and used have to have this bond. Disclosing customers as far as what parts to use, all Maine new car dealers, if you don't put an original part back on the car, you have to disclose whether it is or it isn't. That's to be fair to the customer and let them know the difference between a so-called aftermarket part and a factory part. So anyways, these points that I brought up are nothing that is required by either the manufacturer or the state. And I think someone said a while back, all we're trying to do is level the playing field. So I'll leave it at that.
Yeah, Chris, this is
Yeah, Tim?
Tim Winkler from VIP. I guess obviously, with all due respect to Jack, I think that list and the other recommendations of these burdens that are being proposed to put on independent repair facilities, this and the definition that we've operated with in the independent repair community about leveling the playing field is really simply about accessing the same data that a car dealership or manufacturer's representative can access so that we can continue to operate the way the industry has always operated, which is as cars get older, they stop going to dealerships and they start going to independent repair shops where they tend to get lower prices and it's more convenient with more locations. I find the vast majority of these bulleted numbered items, 1 and 2, I don't know enough about 2. 1 doesn't, the cybersecurity rules around telematics data, that's, I think, you know, we definitely should, the committee should definitely have their eyes on that. But 3 through 6, I find to be huge overreach for what this committee is supposed to be trying to do, which is to just simply address how access to data should be on a level playing field. This should have nothing to do with anybody disclosing certifications. Quite frankly, what I read all of that to be is the car dealerships and manufacturers. This is the exact problem that why it's been so hard for our industries to come together and find common sense solutions. Because if you read these, it's essentially saying, let's scare every consumer out of an independent shop back to a dealership. That's what I read in those bullets. And that's not been the way this industry has operated for the last 100 years, nor should it be the next 100 years.
I mean, I'll just offer my own comments, and I'm mindful of what I said at the very first meeting, which is that we're going to try to come up with consensus recommendations, but to the extent that there are recommendations that some members have that aren't consensus, we're still going to find a way to communicate those to the legislature.
Chris, can I just say one thing?
Yeah.
I think you might have, like you said earlier, might have edited some of this to make it, read better, whatever, but a lot of new car dealers are in the same situation as independents, that we work on a lot of vehicles other than what we sell. And this applies to all new car dealers too. I'm not pointing out independents. I'm pointing out it's for everybody. And it says that in my bullet points. It's for the whole industry. So I'm not trying to pick on the independents. Just want to make sure that to protect the consumer, because there are times when a customer will come in and find out that the car was under warranty, but he had it paid somewhere else and he's trying to collect. It happens more than what you think it does. Just trying to be right up front, so the consumer doesn't have to worry about something later on down the road. That's all.
I definitely respect that, Jack. And what I was going to say is that, what my thought and intent was that the recommendations, sort of the non-consensus recommendations that we'd be including in the report, would be recommendations that would relate to the role of the independent entity. And I think 1 and 2 of the bullet points, I think maybe there's something that we could use there, because I think cybersecurity and privacy. I agree. I don't think the Gramm-Leach-Bliley Act applies, and even if it does, it's not like Maine has the ability to make a federal law apply or not. But certainly, I think we could incorporate some kind of recommendation for the independent entity to consider cybersecurity rules and privacy concerns. But I think these other recommendations really don't go to what the purpose of the independent entity is supposed to be, which is to be working in this area of access to telematics data. I think these are recommendations that, good or bad, they go to a different issue, which is, for example, the extent to which independent repair facilities should have to disclose certain information to consumers, or the extent to which they should be bonded. And I just don't think that's what the independent entity is charged with doing. So, I think I sort of agree with what Tim and Jeff said, which is that I just don't think that those other recommendations belong in this report, because they don't go to what the job is of the independent entity.
This is Brian Boggs from Tesla. I do think item number 2 is relevant for the committee to consider, not necessarily whether Gramm-Leach-Bliley should apply, but rather whether the privacy protections contained within it are worthy of consideration. They relate to the disclosure of what information is collected, how it is collected, and how it is secured and handled upon receipt by the dealership, and what is the disposal process of that data. And so as we're considering a level playing field, it's worthwhile to consider if the new vehicle dealerships need to operate under these particular guidelines, then why would it make sense for different groups to operate under a separate set of guidelines? So I think the idea behind some of these privacy protections are worthy for the committee to take a closer look at.
Yeah, Jeff?
I agree,
But-
Brian.
So with respect then to 1 and 2, and it, you know, I do agree with Jack's comment with respect to, you know, application of these items to those stakeholders involved. And so with respect to the language specifically in paragraph 2, it sounds like we can get rid of the Graham-Leach-Bliley reference, but there's also a reference to independent repair facilities. As there is in items 3, 4, 5, and 6. Specifically, you know, should this apply to independent repair facilities? I certainly have no objection to the comments with respect to what cybersecurity rules should apply, and what you know, privacy protection should apply. But you know, to everyone involved in the process, I think would be perhaps more fair.
Yeah, I mean, what I was wondering is if we just sort of rephrase 1 and 2 to something along the lines of, you know, what cybersecurity rules should apply. Well, that one's right there. What cybersecurity rules should apply to telematics data, and then, you know, the extent to which privacy protections should be applied to telematics data. So not make it just the independent repair facilities, but just generally talking about telematics data as a general matter. And then, you know, the recommendation would be for the independent entity to consider sort of the privacy and cybersecurity implications of that data. Is that Jeff kind of what you, yeah, okay.
And Chris, just, I'm sorry, this is Tim again, just to,
Yeah.
I guess, reiterate another point that I think I've brought up in other sessions is we sometimes get into these conversations as if it's like only a dealership or only an independent repair facility, but I keep saying that these cars that are coming out today that have all these new technologies are going to be 20 years old someday with a lot of do-it-yourselfers working on their own cars. So that's the other reason I think we need to strip this from saying, well, here's a new requirement on independent repair facilities. If we decide there are cybersecurity concerns or privacy protections that need to be within this process, it needs to be for anyone accessing that data remotely, let's say telematics data, and that would apply to I suppose, the consumer themselves, or, you know, somebody who's working on a car as a neighbor who works on cars. I mean, that happens all the time too. I take my car down the road to my neighbor because, you know, it's the most economic way for me to fix this old car. If we're going to put these requirements in place for accessing remote data, it should apply to in any scenario where that is being done. It shouldn't just be targeted to one specific group of repairs.
Hey, Chris, if
This
you
is-
want to take
Okay,
out
I've
the,
had my hand up.
Let me,
for a while.
yeah,
Sorry.
Elizabeth did have her hand up. Let me just start with her.
Thank you. So I think I just want to back up a little bit because I'm a little concerned about wordsmithing the other recommendations section. I wonder if, so from my perspective, I think it's perfectly appropriate for the report to contain recommendations specifically included from other parties, so long as they're expressly identified as coming from those other parties, and again, not consensus. I think that does have to be very clear. Whether they're included as, you know, appendices or some factor, I think it is appropriate. We sort of opened that up. We gave that opportunity for us to now start trying to come to consensus on the other recommendations that are not consensus recommendations, I think presents a problem. And I do think we're kind of all in or all out here on the other recommendations. My strong preference would be for inclusion of them as they were submitted, and that's clear in the report that they're included as submitted, not consensus, just additional items for consideration raised by members of the working group. So that's not specific to the specific items. I just think if we start trying to get consensus on these, we've defeated the purpose of the section, which is slightly disingenuous to, I think, where we set out to go right from the very beginning.
And before you go, Jack, let me just comment on that. So I think at least in my mind, what the difference is that it's not that we're trying to get to a consensus about whether these are things that should be looked at or not looked at. It's just that the independent entity, this just seems completely out of the sphere of what the independent entity is supposed to be doing. Like, I don't think anyone envisioned that the independent entity would be deciding whether repair shops should be bonded, or whether they should have to post a sign saying that they necessarily don't use official manufacturer parts. Like those just seem like completely different issues to me. And so I definitely hear what you're saying, Elizabeth, that, you know, we did open the door and say that we would include non-consensus recommendations, but I think those recommendations have to relate to the work of the independent entity. And I just don't see, you know, 3, 4, 5, 6 as sort of going to that. Jack, did you have something?
I know, I understand where you're coming from, Chris, and, you know, as far as the wordsmithing is, maybe instead of saying independent, we just say automotive repair facilities, take the word independent right out. I don't have a problem with that. I'm not trying to discriminate against one versus the other. I'm just talking about automotive repair facilities.
Any other comments on this section, the section involving Jack's recommendations?
I have a comment. One of the proposals somebody brought up was to make item number 2 a bit more generic, to have a recommendation for the committee to consider these privacy protections. But if that was done, it might lose some of what Jack was trying to convey, that the new vehicle dealers are already operating under these privacy protection guidelines. And so it might not be readily apparent to the committee that the dealerships have these guidelines in place, and and that other businesses do not yet have such guidelines in place.
Anything else on this one?
I would second that point from Brian Boggs. This is Michael. I guess Graham Leach Bliley regulates car dealers, but it might not regulate other entities that repair cars. And so I would be in favor of retaining a reference to Graham Leach Bliley, just so that the rules, the privacy rules that restrict dealers, are the same as the privacy rules that restrict other car repair facilities.
Yeah, I mean, I guess, well, first of all, like I didn't understand that Graham Leach Bliley applied to car dealers, but maybe it does. I just don't know for sure. But even if it does, either it does or it doesn't under federal law. So it's not like the state of Maine or the independent entity or any of us can decide, okay, we're now going to apply the Graham Leach Bliley Act to independent repair facilities. It's just a matter of federal law. Either they're subject to it or they're not. So I would be in favor of, you know, some sort of recommendation that the independent entity, you know, look at privacy concerns that relate to the disclosure of telematics information, just as a general matter, because I think those concerns could arise in various contexts. So that's why I would just keep it general. Yeah.
Chris, my take on the Graham Leach Bliley reference, and once again, I'm all for making privacy a bulleted item for, you know, attention there, but this looks like it applies to car dealerships because they're financing vehicles. It's the financing of loans and things that brings Graham Leach Bliley into play. That's not a normal operation of an auto repair facility anywhere. And so I think that's we offer a Citibank credit card through Goodyear. So if we want to apply Graham Leach Bliley to Citibank, that's fine, but that's not a VIP operation.
Yeah,
I think, Chris, I think keeping it vague inside of that instead of evoking a federal bill, which we're not even sure, has anything to do besides loans for new car dealers or anything in the banking world of that. I think it makes sense to keep it vague, as you suggested, because I think, personally, I think the independent entity is already going to explore this, but putting in a federal statute to me doesn't make a lot of sense when you can keep it general.
And Eric, I think you had your hand up at one point. I don't know if you had.
Yeah, I was just doubling back on actually what Tommy's recommendation was. I believe, Tommy, I don't want to speak for you, but on anything that we decide to keep in, there should be some way to highlight those that agree and those that don't agree, to give some added perspective as these things, anything that stays carries forward. I think that's where you were going, Tommy, earlier.
Yeah.
So I don't know if we're going to do that or not do that on this one, but I do think being able to highlight things that are staying in as recommendations, and then if there's members of the group that feel strongly one way or the other somehow being able to capture that.
Any other comments?
One last comment for me. The report isn't necessarily recommending whether that this federal statute apply to Maine, but rather it's informative or educational in nature to highlight the facts of what already exists. So perhaps Jack or others can rewrite this portion to just be transparent of this is the current status of what is obligations new vehicle dealers have in this area, and to be transparent that these obligations do not apply to other businesses, and that the committee should take a look at whether what they should do in this area.
I mean, it's not clear to me, and maybe Jack, you can clarify, what is the source of the obligations for new car dealers for privacy protections?
First thing is that you have to have the customer come in and sign a privacy notice, what we do with the information, because that's where it all starts. Second thing is identification, getting the right identification, make sure that that person is that person. Those are some of the big highlights. The other things they're kind of a pain to us, just like everybody else, is that the data that we collect, whether it's servicing a vehicle with a repair order or a sales order, it has to be under lock and key. It has to be filed. It can't be sitting on someone's desk. You can't have an open screen computer so someone can come by and see the information. Quirk pays $600 a month to hire a company to follow these regulations. It's not cheap because of the data, because of the privacy acts that are out there. I believe the state of Maine, your office is in the process of putting this all together, your privacy laws. So it's coming, and it's coming more. And again, like I said, the consumer should know exactly what they're getting into when this data is going to be extracted from their automobile. That's
right. I mean, my proposal is this, that I think I have a pretty good sense of where everyone is on this issue. My thought is that Christine and I can look at revising numbers 1 and 2. But I think 3, 4, 5, and 6, I just don't feel that those belong in this report. I just think those have nothing to do with what the independent entity is charged with doing. So my thought is in the next draft, we'll just take a look at revising numbers 1 and 2. All right, so since we started at the bottom, why don't we just work our way up? So the next recommendation came from Tesla, and that was about excluding coverage for commercial and heavy duty motor vehicles. Any comments on that? Yeah, Jeff?
So, I mean, I could certainly have specific comments on this and whether or not we tackle this item in particular or the other items which, seek to delay the application of the law or talk about uncertainty of the law, and therefore it's not fair to enforce it straight away. I mean, to the extent, and I'm happy to talk specifically about why I disagree with those items. If we want to have that debate, let's certainly do that. I don't think that those comments are out of bounds for members to make. I would just simply echo what Tommy said with respect to let's call out who's advocating for that position, and then let's carve out a little bit of additional room, in my opinion, to the reasons why certain other members would oppose that. And so everyone, has an opportunity to say, I think we should postpone the application of the law, and then other members should say we should not for these reasons.
Yeah, I mean, that sounds reasonable. It sounds like what you're proposing is sort of some members recommended this, but other members recommend that you don't do that, and here are the reasons just to match it. Okay, yeah, I mean, that sounds reasonable to sort of give people who don't agree with the recommendation just a chance to go on record as saying that they're not this is the reason why we don't agree with that recommendation. Is there anyone who doesn't? Yeah, Elizabeth?
I'm going to start to sound like a broken record. Is there a reason we can't, rather than call them recommendations, call them considerations and include the language as it came from the working group members? I've seen this in a lot of other report outs from these types of study groups, and it would preclude us from having to go through this exercise. I also just have to say, I'm personally very uncomfortable with the direction we're headed in with revising these. It seems like there's been a determination made, and I, for one, am not in the consensus on that determination. So I want to make that clear.
Well, so let me just follow up on that a little bit. I mean, whether we call them, let's say that we call them considerations. And so we have, something that would say the Alliance and Tesla think that consideration should be given to delaying implementation of the telematics piece of the law. And this is why they think that should be considered. Then they have sort of a little blurb here that explains why they think that should be considered. It seems fair to me that if two entities are going to be able to explain why they think there should be a delay, it seems like it's fair to allow other entities who don't think there should be a delay to say why they think that there shouldn't be a delay. So all I'm suggesting is that we give everyone an opportunity to address it rather than just have a single consideration without anyone being able to express sort of what the contrary consideration is.
I have follow-up.
Yeah.
I guess my follow-up to that would just be that it was very clear that we were all invited to submit additional considerations for inclusion in the report that were non-consensus items. So I think everyone had an opportunity to say everything they wanted to say, and that we're essentially saying, here's what's left, right? We're essentially saying, and this party feels that this is very important. And if the other side wants to submit information saying, whatever they want to say, I mean, I just think that that's what we set up, and we're now going back and revising that. So I'm just uncomfortable with that direction.
Yeah, Jeff?
So first of all, until this draft was published, I had no idea what the new motor vehicle dealers might say or what the Alliance's position might be specifically with respect to these items. And so I think this is an appropriate forum to address those items now. The other thing that I would say in response to this is I think that the working group should consider the audience. I mean, this is a report that's going to be read by people who are not members of this working group, who are not involved in this process. And to say that certain members want to consider certain items without giving a response or a counter consideration to that, I think leaves that out and would be inappropriate.
Any other comments?
Yeah, I follow.
Yeah, Elizabeth?
I'm fine if we want to have a, response section. But I think if we do that, then the language has to be verbatim the way it was submitted and not an edited version that then also gets a response.
Well, I mean, certainly I understand if you think that the edited version isn't consistent with sort of what your recommendations were, but I mean, we really worked hard to not change the meaning or the intent of the recommendations. We just tried to make it more concise. If you have objections to the way that we've reworded it, like I'm certainly amenable to taking another crack at it. But I guess what I don't want is just like anything someone writes down just gets inserted into the report. Like I think our office needs to have some ability to actually craft the language. And again, not in a way that changes the meaning or the intent of the person who submitted it. But again, I just don't want to be in a position where we just reprint whatever someone puts down on paper.
Okay. I will say, I mean, with respect to the recommendations coming from the Alliance, I'm fine with the way they're worded. I think my concern is on behalf of the language that was submitted by Mr. Quirk, because that a determination has been made that items 4, 5, and 6 are irrelevant to the discussion and to the report, and I'm just not sure that that's appropriate.
I understand there's difference of agreement, and Christina and I will have to talk about that and sort of figure out as chairs and members of the AG's office sort of what our role here should be. But I guess I'm inclined to, just because I honestly think that these other recommendations from the dealer member, I just don't think that those are consistent with what the purpose of this independent entity is going to be. But I definitely understand that not everyone shares that view. Okay, so
Chris, I had a
Yeah.
question for you.
yeah, Brian.
If we were going to include in the report, in this other consideration sections, additional perspectives for each of the topics raised, how many iterations do you think we will go through where if we now include like the minority opinions for each of the minorities, and then we take a look at it and you also do some wordsmithing to help make it more concise. I'm just wondering how many iterative sessions you envision will go through.
Yeah, no, that's a great question, Brian, and certainly went through my mind. Are we going to have reply briefs, sir replies, sir rebuttal replies to everyone that's someone writes down? I think we just have to cross that bridge when we get to it. What I'm hoping is that any sort of other recommendations or considerations that come in, no one's going to feel the need to respond to those. But if someone does, then maybe we have to allow people to update their original recommendation. I don't want to make this into a thing that just goes back and forth forever, and I don't think it will. But I think we have to wait and just see what sort of language people are suggesting. And, to the extent that people are able to, if they can maybe craft the language in a way that's not going to generate a lot of back and forth, like that would be helpful. Like what and what I mean by that is try not to be argumentative. If you can just say, very in a straightforward way, for example, why the law shouldn't be delayed, and just give the reasons for that. I'm not sure there's anyone's going to feel a need to respond to that, but again, I think we need to cross that bridge when we get to it. But Brian, I definitely hear what you're saying, and I have the same thoughts. So I don't know, unless anyone has any different ideas, I just think we have to see how it goes, basically. I mean, in legal cases, someone gets the last word. And so I don't, you try to let everyone have their say, but at some point you have to close the briefing. So I think we'll just figure out at what point we're going to have to close the briefing here. But my hope is it's going to be maybe just after one more round of people's considerations and recommendations. So, I mean, acknowledging that this might result in more than one more iteration, are people generally comfortable with the idea that we are going to allow an opportunity for people to submit considerations to counter considerations that are in here?
Yes.
Yes.
Okay.
Yes.
All right, great. So then is there anything like, I know that obviously there is disagreements about a couple things about whether heavy duty motor vehicles should be included, whether the statute should be delayed. It sounds like the resolution of that is just going to be that people are going to be able to respond. Are there any other comments about the other recommendations? For example, I know that the Alliance had a couple suggestions. I think one was about giving a definition of the platform. And I think also about the statute being amended to provide for a technologically neutral tool. Are there any thoughts or comments about any of the others? Yeah, Jeff.
So I'm not really sure. I mean, I think that there's been a good attempt to define here what technologically neutral means. I'm not sure what a specific technological solution means insofar as I think what we're talking about here is that everyone anticipates there being a technological solution. And what the Alliance is getting at is that we're just not going to specify what type or what specific technological solution should be available, that nothing in fact should be mandated in particular. And I see Elizabeth shaking her head up and down. So I think that's the way I read this. I think it could also be read, however, to mean that that no technological mandate should be specified, or there doesn't have to be one. And I don't think that is accurate. I just want to make sure that we're all in agreement that we anticipate something. We're just not saying what.
just to put it on mic since I haven't been verbalizing. Yes, Jeff's initial reading of it with respect to there being one and that it just not being specified is correct. So we're not assuming that there wouldn't be, and to the extent that needs to be cleared up, happy to have you take a look at that.
You know, I had the same understanding too. So, yeah. Or anything else on the report as a whole?
Oh,
Yeah, Elizabeth?
yeah, I have one small thing that's in the original. I forgot to bring it up. I apologize. On page, guys, as page 5. Members of the working group, I wonder if we could just clarify, under G, one member representing the public, that it be someone who is a citizen of the state of Maine.
Sure.
That's all I had.
Yeah. I think we probably say a resident of the
The
state of Maine.
resident, yeah, I knew
Yeah.
citizen didn't sound right. Thank you.
Yeah, does anyone have any concerns with that? Okay. All right, anything else on the report?
I guess the second bullet under other recommendations, I guess I'd like to understand more about this comment around advocates for survivors of domestic abuse. I guess is this comment sort of trying to relate vehicle telematic systems to like weapons, or what's the premise behind that comment?
Yeah, that's a good question, Tim. So my understanding, and this was something that Megan Sway had raised representing the ACLU, and I think what her concern is that abusers could use data about the vehicle in a way, for example, to stalk someone, in other words, to get location data from a vehicle. I don't think it was about using the vehicle as a weapon. It was just using telematics information in a way that would allow an abuser to track or monitor the movements of someone. I don't know, Michael, you weren't here for that part of it, but I don't know if you have any thoughts about that.
Chris, I think you summarized it well. Tim, that was Megan's intention, from what I understand. Partner has access to your car location, but you've decided to remain anonymous to keep yourself safe. So how do you continue to remain anonymous even though your partner has location to your car? And so the idea behind this recommendation is to solve that problem.
Okay, no, that's understandable, I guess. I don't know that it's necessarily for this report or not, but my vision of this was that an auto repairer, let's say, I guess one of the problems that this statement, I guess, in my mind, may communicate to a reader is that somehow this process is going to allow a repairer to know the location of a vehicle at all times, which was never necessarily sort of within the realm of what we're trying to accomplish here. What we're trying to accomplish here is, someone has a vehicle they need repaired, they show up at a shop, they give us access to be able to get to any remote data we need to fix that car, and then that data itself is no longer relevant, and there was never under consideration sort of location tracking by, through this process. So I guess I wouldn't want the statement to mislead legislators to thinking that somehow that this is going to potentially expose location data of vehicles outside of the repair shop.
Yeah, and maybe, Tim, there's a way that Christina and I can just sort of take a look at maybe tinkering with that language a little bit. I didn't read it that way. I mean, it didn't ever occur to me that this was sort of, suggesting that independent repairers are going to have that kind of access. But I guess what we were thinking is, let's say that there's an app that the person has access to their vehicle data with, and maybe the abuser is able to get access to that phone or that app. Like, I don't really know how this would all play out, but I didn't read this as suggesting that like independent repair facilities were going to be engaged in blameworthy kind of behavior. But maybe there's some language that we can add that will just sort of make it clear that that's not what this is intended to suggest.
Okay. Yeah. Thank you.
Also, Chris, did you envision us like addressing some of the other considerations that were put in the last draft, so much as like the delay and the definition of a platform, or are we just going to do that? Did you consider we just do that in writing, or how did you want to kind of
Yeah, so
approach that?
why don't we talk about that's a good question, Tommy. My thought was, because I know there are people from the public who want to get a
Yeah.
chance to talk, and I recognize that their time's important. I don't want to delay that part of this. So my thought is once we finish going through the report, and I think we're just about done, we go through the statute, which I'm hoping there's not going to be a lot to talk about the statute. Then we hear from the public, and then at the end we can talk about when our next meeting is going to be, and then we can also talk about a process for people to submit additional recommendations or considerations. Does that?
Yeah, understood.
Okay.
Understood.
And Brian, do you have your hand up?
Yes, I wanted to make a comment about the domestic abuse section. As you're considering clarifying the wording there, I think the item that is worth noting is, and we discussed this in one of our in a couple of our prior sessions, that although diagnostic information and repair and maintenance information from vehicles is typically used to diagnose and repair the vehicle, it can also be misused for a variety of purposes, and that is not necessarily readily apparent to the public or to the committee. So I think the item to highlight here is that even without knowing the location of the vehicle, if it's entirely possible to utilize repair and maintenance information such as vehicle speed and what gear or when the vehicle was placed into gear for inappropriate means, such as at what time of day was the vehicle first put into drive, at what time of day was it parked, and in using those pieces of information, you can see when a person left their home for their work, when they tend to get to work, when they leave work, and when they go back to their home. So I don't know that that is blatantly obvious to the committee, and it's worth their consideration as they consider hearing from these advocates for survivors of abuse.
Okay, yeah, thanks, Brian. That's helpful. Jeff?
With respect to this concept of misuse, I think maybe if we could craft the language in such a way as to make it clear that, to the extent that this information is available telematically now to a manufacturer's authorized repair shop, that it is subject currently to misuse of those employees of that repair shop or potentially employees of the manufacturer. And it's not just a independent repair shop or aftermarket item. It is an item that should touch and affect then every stakeholder involved. I just want to make sure that that's clear. I don't think that's controversial in any way, because there can be bad people, anywhere. But I just want to make sure that we don't point the reader in a direction that's unintended, to Tim's point.
Yeah, so said another way, it's a risk that's already out there. This just takes that risk and enlarges it to wherever telematics data is being used, which is a limited set of facilities today and would be a greater number of facilities, based on the work of the commission.
Elizabeth?
Yeah, no, I'm fine with the direction all of that's going. I wanted to just add that I think it's certainly appropriate to have discussion of this and to have it in the report. The original letter from Attorney General Fry actually noted that the working group could consider privacy and cybersecurity concerns relating to potentially sensitive motor vehicle information. So I
Yeah.
think it's appropriate, and I like the direction that we're headed.
Okay, great. All right, anything else on the report? All right, going once, going twice. All right, so then the other thing that we circulated were some red lines to section 1810. And so this just so everyone is on the same page, our plan is to attach a red line version of section 1810 to our report, and it would be in the context of recommendations from this group regarding potential amendments to the statute. So let me, and they also, match up with sort of the recommendations we're making about the working group. In other words, it sets forth the process for the selection of the members. It sort of modifies what the duties of the entity are going to be. And then there are also some other changes that were put in here. So let me ask if anyone has any concerns or questions or proposed additions to the statute that we circulated. Yeah, Jeff.
I'm not sure whether I have any objections to the language in paragraph 6 that was added, but I don't know that, just take, notice that I'm not the brightest bulb here. I'm not sure why receive data and was added. And I'm not sure why, and that the manufacturer makes available to its authorized repair shops was added. And so, maybe if I could have a better understanding about that, that would be helpful to me.
Yeah, so Brian, I think this was your language that you suggested. This is the part where you added the ability to receive data and then that they make available to authorized repair shops. Can you, and I think you may have explained this in our last meeting, but can you just explain again why you think this is language that should get added to that section?
Yes, I'll start with the second half first. And that the vehicle manufacturer makes available to its authorized repair shops. I believe that this clause is closing an accidental loophole or gap where, as I read the legislation today, I interpret it as meaning all data and all commands that are used for repair and maintenance that are available when you're locally present at the vehicle also must be available when you're remote to the vehicle. And that in the status quo world of today, the vehicle manufacturer can exercise good judgment to constrain itself and its dealerships and automotive repairs to simply not have access to perform inappropriate commands remote. And I gave the example of releasing the parking brake. It does not make sense to be able to release the parking brake when you're remote from a vehicle. That vehicle may be on a hill. It would then roll down that hill. And I don't think that's what is intended by this bill. And so by including this clause, it's for sure still creating the level playing field. It's saying any commands that the vehicle manufacturer makes available to its authorized repair shops, it also needs to make available to independent repair shops. And the clause to say that it included the addition of receive data is just to clarify that this sentence relates to data and commands and was not specific to commands. So it's essentially saying any data, any commands that the vehicle manufacturer makes available remotely to its authorized repair shops, it needs to make available to non-affiliates. Does that clarify? Or do you have additional questions?
Well, I'm sorry.
I'm sorry.
Let me just have Jeff go first.
Understood.
So, I do think that the word commands is later modified by the words diagnostic and repair for purposes of maintenance, diagnostic, and repair. So it's really not all commands. It's commands related to maintenance, diagnostics, and repair. And so maybe there's a difference in my mind and not in your mind about that. And I just don't understand. But
Okay,
what my concern was
that point.
What my concern was about this language was that a manufacturer would use this language to somehow control whether or not an independent repairer or an owner of a vehicle would actually have access to data. And that's not your goal here, is to preclude that. Your goal is to keep something bad happening that manufacturers don't let happen.
Yes, so when we're talking about commands, like the whole scope of this bill is commands or data used for the purposes of maintenance, diagnostics, and repair. And my whole premise is that it's entirely inappropriate and unsafe for everything that you can do while physically present at a vehicle to also be allowed when you're remote from the vehicle. So, going back to the release parking brake example, it's entirely it makes total sense to me that when you're physically at a vehicle working on a car in your workshop and the vehicle's on your lift, that you might, with a tethered connection to the vehicle, send a command that releases the parking brake on the car so that you can access the wheel hub and do some work on the braking system. It does not make sense to me, and it's entirely unsafe to open up such a command to be executed remotely from the vehicle.
Tommy, did you have something?
Yeah, I think I have concerns on how it's written to say receive data. If, in the above sentences, you talk about an owner authorized standardized platform, that's the access to the information. And then when you read the second sentence, it says access to receive data, just as authorized dealers receive it. So we would read that as being contradictory to the above sentence. I'd also like to say that I think, we're not really talking about what dealers get versus independent repairers. And Brian can correct me if I'm wrong, but I believe Tesla, the manufacturer, has the ability to send a lot of commands to directly to vehicles. So they may not share that information with a authorized dealer, and then an independent repair shop would not get the ability to send that command. So those
commands would only be not used for the purposes of maintenance, diagnostics, or repair. So I don't see this like the receive data and send commands. My intention was to actually put it in line with the beginning of the paragraph. Like the beginning of this paragraph, yes, it's talking about the combination of the two, receiving data and having access to data and being able to execute commands. And so when I added that clause to this sentence, I was just trying to maintain parity with the first portion of the paragraph, that this sentence also relates to data and commands, that any data, any commands that that are used for purposes of maintenance, diagnostics, and repair, that the manufacturer makes available to its authorized repair shops, it also needs to make available to others. And that phrasing is, I lifted it like word for word from the prior sections in the bill, which relate to access to repair manuals and diagnostic software and scan tools and other items. So like this edition in section 6 is like word for word the same phrase and clause used in prior sections.
Yeah, I think we just, like I said, I think we just object to the fact that you're talking about the ability to receive data and the ability to send commands as authorized dealers. That's the way I read it when you put in receive data. And, like I said, manufacturers are the ones that are sending commands to vehicles. And we do say for diagnosing, maintaining, repairing the car. And so if you wanted to say something in there, it says in a safe and secure way so as to not allow an independent repair. I mean, we expect the manufacturers to design this system so that no bad repair could happen remotely. So if you were going to put something in there that we believe to be redundant because it does say safe and secure above, so to say that the ability to send commands shall be done in a safe and secure way, or as a manufacturer does themselves for the purpose of diagnosing, maintaining, and repairing.
So let me just jump in. So it does sort of seem like the received data is redundant. And so like what I sort of understood this paragraph to be saying is it starts out with talking about the secure platform, and you have to be able to get all of this information off of the secure platform. So you're receiving all this information from the platform. But then I sort of see this next sentence that we're talking about as, and by the way, you also have to allow for, the sending of commands, because that's something different than all of the preceding parts of the paragraph we're talking about. So, okay, up above it talks about receiving information. And by the way, you also have to be able to allow to send commands. So I do think that the received data is redundant. And so what I'm wondering is if we strike that, can we still keep in what Brian is suggesting? Because I do understand his point that a manufacturer, I think what you're saying, Brian, is if there's certain commands that manufacturers don't allow dealerships to send to vehicles, like unlock the parking brake, the manufacturer shouldn't have to allow independent repair facilities to send that command.
That's right.
So what if we took out receive data, but then kept in and that the manufacturer makes available to its authorized repair shops? Then at that point, we're only talking about the ability to send commands. Tommy, I'm sorry. Go ahead, Brian.
As long as everyone agrees that the same applies, that we're talking about the data that is needed for purposes of maintenance, diagnostics, and repair, that the manufacturer makes available to its authorized dealerships. Because, like, from a privacy perspective, there can be data on the vehicle that maybe is only appropriate to see when you're physically at the vehicle. And so again, the core thing I'm trying to distinguish here is to allow there to be a difference between what is available to any automotive repairer, regardless of who they work for, whether when you're physically at the car versus when you're remotely at the car. And that I think is super important from a privacy standpoint, from a cybersecurity standpoint, from an automotive safety standpoint. And so that is the core distinction, is to allow there to be difference with both data and commands when you're local to the vehicle versus when you're remote from the vehicle.
I think my concern, Chris, with keeping authorized dealers is that manufacturers send the commands directly to the vehicle. So that if they were not to share that information with an authorized dealer, it would bypass the independent repair and the dealership, and they would send the command to the vehicle. Now, Brian has said that manufacturers have the ability to send these commands in a safe way, and we want to do it in the same manner. So if you were to change how the independent repair and the manufacturer create parity on how they send commands for diagnosing, maintaining, and repairing a car, I think that's something we'd be okay with. But it'd have to be the manufacturer, not the dealer.
The other portions of the bill, I'll find the section here. In the last sentence of section 4, the last sentence of section 3, use this same phrase. So that seems appropriate for me.
Those sections aren't telematics, though. This would be in terms of telematics, and that's why we feel as though
we're talking about repair and maintenance information, regardless of where, whether it's telematic data, whether it's you're tethered to the car, whether we're talking about the service manual, the wiring diagram, the parts manual, training information, and any information. We want there to be equal parity between independent repair shops and owner and manufacturer affiliate workshops. That doesn't really matter who employs the workshop, that they have equal access to all of this information that's used for repair and maintenance. So if a manufacturer, if there's some command that a manufacturer is making available to no one, it doesn't make it available to any of its dealerships, why would it make sense why is that command needed for parity? If it's not available to a dealership today, I don't understand why it would be parity to begin making it available.
Because Tesla sends commands to vehicles directly without sending it to their dealerships. Is that not correct right now and in the future, Brian?
Not for repairs and diagnostics and maintenance.
So
Vehicle
everything,
manufacturers have a unique obligation as the providers of the operating system of the vehicle in order to conduct over-the-air software updates or to make new features available. These are like outside of the scope of automotive repair. And so like I actually see this clause as being a great way to really focus in on the core of what we're talking about here, which is automotive repair, whether it's done by the owner themselves or their neighbor down the street or an independent repair shop or a dealership, that all these groups are getting the exact same information, they're getting the same data, they're getting the same ability to send commands, and they're getting all this parity, whether they are locally at the vehicle or whether they're fully remote and interacting from it remotely. But they're, yeah.
yeah. So my
Wait, hold on. Tommy, Jeff,
ahead.
Jeff's been just waiting to say something.
Would it be possible to harmonize what Brian and Tommy are saying simply by keeping Brian's language and then adding "or to the vehicle" at the end? Maintenance, diagnostic, and repair, and that the manufacturer makes available to its authorized repair shops or to the vehicle?
Directly to the vehicle.
Yes.
I think the problem with that I see is like now we've just opened up the scope to any electronic digital communication between anything outside of the car to the car for any provided digital services and that are outside the scope of maintenance, diagnostics, and repair. Like the example I gave of the obligation from the vehicle manufacturer to provide over-the-air software updates, and that they're doing this to maintain cybersecurity in the runtime operating system or to make new features available, and that these things do not relate to automotive repair by dealerships, workshops, independent repairers, or owners or their neighbors.
I'm sorry, I don't understand why that would open up everything when the language that comes before it is specific to maintenance, diagnostic, and repair information. So in my mind, it doesn't open it up to anything other than that specific subset of information, which is the information needed to repair the vehicle. Not all commands, not everything else, not supported services, not Sirius XM radio, not, whatever your version of OnStar is. I mean, it's just very specific data.
Sorry, could you?
Yeah, well, let me just, I think Jack
sure.
was
Yeah.
first, yeah.
Just maybe put it more in real world. There are times when a recall is initiated by the manufacturer. Vehicle is brought in, we hook it up, and they download information. The dealer does not fix the car itself, it's just downloaded, and it's the software that they're updating in that vehicle. Some of us dealers don't like that idea because we're not getting paid to fix the vehicle either. But the manufacturer does do that sometimes even when the car's running. So I can see what Brian's coming from, is that I don't know if this would be something that all independent stores, including us, would have a right to, because all the manufacturer's doing is maybe updating something that the government asked them to do, emission controls or something like that. Sometimes you get an erratic shifting pattern in your 10-speed transmission, and it's all synchronized by computers. And you hook it up, you go in, you flash it, done deal. So again, I can't imagine the manufacturers letting that information out. The other thing I want to bring up is all that information is encrypted. We can't, if we do see it, we don't understand it because it's all encrypted. So, I can see where he's coming with on that point, that I think somewhere along the line, the wording should be that information that is just being downloaded by the manufacturer to make the car run the way it's supposed to run, because of some software issue, is is done. We don't like it either.
But just before we go to Elizabeth, Katrina has joined us. Katrina, can you just introduce yourself?
Hi, Katrina Fitzgerald, Deputy Director of the Electronic Privacy Information Center, or EPIC.
Great, thank you so much. Elizabeth, did you have something?
Yeah, yes, actually, I was just hoping Jeff could repeat. Could you repeat your suggested language, just where you had it? Because now I'm thinking I didn't hear you right.
Well, it was at the end of the sentence after the word shops.
Yep.
Just or to the vehicle or directly to the vehicle. It seemed to be that there was a discussion about whatever the manufacturer's authorized repair shops. And then Tommy made the point that sometimes information goes directly from the manufacturer to the vehicle. And so I thought that that might harmonize those two concerns.
Thank you for clarifying.
So I think we've tried hard to reach agreement on language, but it doesn't seem like we're going to be able to, at least not easily, I don't think. So Brian, one thought I had is whether you just want to make this as a recommendation on the part of Tesla in sort of the other section.
I don't think it can be just a recommendation. Actually, it's like this sentence, that's the entire motivation for me to be in this working group. I saw that this accidental loophole, which as I interpreted the bill, it implies a mandate that all data, all commands that are available locally must be available remotely. That's like the biggest challenge I see with the original wording of the bill, and that like we as a working group need to find a path forward for. And I think Jack brought up a great example that in the execution of recalls, or just to meet federal emission standards, that there are capabilities, that there are like digital configurations on the vehicle that the vehicle manufacturer may need to modify in order to comply with a NHTSA mandate or some other EPA mandate, that in doing so, in changing that configuration, the ability to change the inherent definition of what the car is and how it operates is not made available to authorized dealers, as the vehicle would no longer be the vehicle that was originally homologated or filed for sale in the state or in the country. So if the clause, I forget the wording, but the and vehicle addition or sent to the vehicle at the end was included, that seems in conflict with the idea that, or not even just the idea, the reality that there are certain portions in the inherent identity and configuration of the vehicle that the manufacturer has obligation to maintain, and that it does not make it, does not allow modification by entities, whether they're affiliates or independents, other than it itself.
Brian, does it make a difference? I mean, not to maybe belabor this, but it does say that these are only commands that are needed for purposes of maintenance, diagnostic, and repair. And so, and that seems like a big limitation that's not going to include sort of a lot of the things that you're talking about, I think.
Yeah, I think any command, any tool can be used for a variety of purposes. So I actually think the clause and that the vehicle manufacturer makes available to its authorized dealerships is a great way in this section and in other sections when we're talking about the repair manual, service manual, wiring diagrams. A vehicle manufacturer generates in the design and engineering of its car many wiring diagrams for and like internal traces on different PCBA and electronic components, and it does this for the design and manufacture of the vehicle. This information is not made available to authorized repair shops because it's not used for purposes of maintenance, diagnostics, and repair. But somebody could, look at it and find a way to use it for maintenance, diagnostic, and repair. I guess I see that the vehicle manufacturer makes available to its authorized repair workshops as a great litmus test for, is this thing, whether it's software, whether it's data, whether it's a command, whether it's a repair manual, it's a great litmus test of, are we talking about something that's actually used for maintenance, diagnostics, and repair? Because if the manufacturer's not making it available to its dealership, then it sure feels like it's not being used for maintenance, diagnostics, or repair. But does that make sense? Or
that doesn't. So Tommy, let me ask you this. I mean, I think one of your concerns was that some manufacturers might send the commands directly to the vehicle, and this could sort of be a loophole potentially. But it sounds as though, at least for Tesla, the commands that they might be sending directly to the vehicle are things like software upgrades and other kinds of things, not commands that then the dealership is going to use to make a repair. And I think I heard you right about that, right, Brian?
Right.
So Tommy, given that, are you still concerned about the proposed language?
I am. Yeah, I think manufacturers are in different places. I think technology is evolving, and I believe that manufacturers have admitted to the fact that they send commands to vehicles to diagnose, maintain, and repair the car. So I think if a manufacturer can do it, a consumer should allow an independent repair to send said commands. Now, look, if this is something that Brian wants to put in the report, that the engineers can get together and facilitate some kind of agreement, then I think that's something worth exploring. But where we stand right now, we want to make sure that the independent repair can send commands to the vehicle just as the manufacturer does, in a safe way.
Even if the dealership can't send those commands, like I don't understand. The point of this bill is to achieve parity in a level playing field, and it just seems in a different direction than the intention of what the voters were voting on.
Well, voters actually voted to empower themselves to get this information so that they could dictate who gets the information. So I think parity, when you're talking about manufacturers sending to dealers, to independent repairers, it should be the consumer that decides this. I mean, a lot of software updates are needed to make full repairs on vehicles these days. And so we don't feel comfortable having the manufacturer, whatever the dealer gets, the independent repair shops get. We think it's the consumer that should dictate where that information goes to make a full repair.
What if, and maybe this is sort of a follow-up on one of Tommy's suggestions. Brian, would it make a difference if we added language that talked about the ability to send commands, so long as such command shall not pose a safety or other risk or something, like a safety risk, basically? Like, would that address the issue in a different way?
I worry that the AG office, will then get bogged down for years to come in determining what is a safe command, what is an unsafe command. And you'll have a variety of experts come in litigation, all claiming what is possible, what is not possible, what's safe, what's not safe. Having this defined litmus test, which is used in all these other sections when we're defining the diagnostic scan tools and when we're defining what service manuals need to be available and what wiring diagrams need to be available. It's like proof by definition of was this thing made available to an authorized repair workshop, like yes or no, as opposed to, was this command subjectively determined to be safe or unsafe, and one in a variety of different settings or contexts. It just seems so nebulous and hard to enforce.
Yeah,
Just,
so
uh,
let me just
uh,
hold on, Tommy. Hold on. I mean, I'm not saying you're not making a compelling argument, Brian. It's just that we have a statute that's been enacted, and you're proposing an amendment to the statute. And I'm not saying it's a bad proposal, and it might even be a proposal that the AG's office would support. I don't know. We'd have to think about it some more. But the problem is that we have at least one or maybe more members of this group that don't want to make that change. And
Mhm.
so I don't know what else to do with this except to tell you that you should put in the other recommendations section a statement about why you think this change should be made to the statute. And it might be that other working group members will also join on to that recommendation. But unless we can get consensus, I just don't think we can do anything other than have you included in the other recommendations section.
Yeah, I guess I find it odd because we've talked about this clause earlier, and actually when the experts came in from I'm trying to remember the guy's name, and we were talking about the trust concept and sorry, his name's escaping me at the moment, but he totally understood what we were trying to do with this sentence, and that it was inappropriate to have all commands be available remotely. And yeah, I actually thought that this clause was going to be this non-substantive addition to just clarify. It's not actually changing anything. It's clarifying what's already written in this paragraph.
Yeah.
just,
So yeah, go ahead, Tommy.
just lastly, I mean, I think we can all agree to Brian's point that manufacturers would never send an unsafe command to the vehicle. So the ability for manufacturers to send commands to vehicles for diagnosing, maintaining, repairing a car just as independent repairs, they should both be done in a safe way because it's the same as the manufacturers. So to me, that makes the most sense in terms of creating parity among this, because a manufacturer would never send a unsafe command, as Brian talked about earlier.
It's beyond just safety, though. It's also about compliance. Like the manufacturer needs to comply with various automotive safety standards, with emission standards, with how he originally filed the vehicle for sale and registered the vehicle. And so, like it's just, it wouldn't be appropriate for a command to be sent to a car for that allows the emissions to suddenly be much more polluting than they were before. And yeah, so how about I try to revise this sentence with Chris? I would like us to find a way to have consensus, like to include this in the consensus portion as opposed to the other considerations. So Chris, can maybe you and I work to see if we can come up with some proposals, and then we could run them by this working group with the intended goal that we can have a consensus agreement to the committee, because I do think this is important.
Yeah, I mean, we're certainly going to have at least one more meeting. So I think that makes sense, Brian. If we sort of put our heads together and see if we can figure out some language that we think will work for everyone. If people agree to it, great. And then if we don't, I think then the alternative would be for you just to fall back and include it in the other recommendations and see who else wants to join you in sort of making that recommendation.
Okay.
All right, anything else on the revisions to the statute? Okay, great. So I think we're in a pretty good place with both the report and the statute, subject to this one issue that we just discussed. What I'd like to do now, if the committee is okay with it, is to start the public hearing section of the meeting. So we sent out a notice, and I apologize that it's taken us a little longer than expected to get to the public hearing portion. But we are going to have a public hearing now. We're asking anyone who wants to address the committee to provide whatever information they think would be helpful. We're going to try to keep people to 5 minutes as best we can. And what we'll do is we'll start with people in the room. And then I think what we'll do, Katrina, if I'm right, is we'll ask, once we get people in the room all finished, then we'll ask people on Zoom to raise their virtual hands, and then you'll bring them in one by one. Is that okay? Perfect. And so I see we have at least one representative in the room, and traditionally I think we allow representatives to go first. So Representative Roberts, do you want to? Okay.
Well, while that person is getting settled, do we actually have somebody on the clock?
Yes, although we don't run the clock against legislators, but we will be running the clock after this.
Yeah, there we go. Get used to that again. Good afternoon, Chair Taub and the Right to Repair Working Group members. My name is Tiffany Roberts, and I represent House District 149. As a two-term chair of the Innovation Development, Economic Advancement, and Business Committee, and current member of the newly merged Housing and Economic Development Committee, which will be HEAD, I gotta get used to saying that now, that will receive this report. I sincerely appreciate this opportunity to provide comment on the draft report and statutory recommendations from this group. I have also appreciated the conversations the group has had and questions that have been asked. Both the conversations, questions, and draft language initiated a deeper dive on my end to gain further knowledge on the state and federal level. I will, however, express a little confusion and concern on transparency on the process today. Luckily, I have Google Docs, so I was able to edit this. We are in a situation right now where a draft report and language was sent to the IP list to solicit public comment and feedback, yet that same language has been discussed in context of further revisions before the group heard the comments solicited. Not only does that potentially create additional work for you all, but it's not in the spirit of a transparent process, especially to anyone who could not be here and has or is submitting comments online. It's kind of akin to having a work session in committee before the public hearing on a bill. That being said, I know there's no perfect process. I just, in case public comes in after. While the report addresses recommendations around formation of the entity, it's missing other key elements in the charge of the working group in relation to the entity. To be more specific, the report has really only addressed Section A and lightly on Section B. C through E have been touched on in the individual comments, but not addressed as a group. And even those comments today seem to be in question. I would urge the group to look at each stakeholder's comment in the context of the statutory charge. Without doing so, I'm going to go over 5 minutes now, just so you know, because I had to add more. Without doing so, the overarching statute, while well-intentioned, is rife with ambiguities, potential conflicts with federal oversight, and cybersecurity risks. Despite the detailed assessment, the draft report underscores the challenges in implementing a framework that balances consumer rights, industry practices, and emerging federal standards. I would like to break my comments down into digestible sections. The misalignment of telematics access with current repair needs. The law's telematics access provisions are a cornerstone of the debate, which has been very clear today, but their necessity and practicality are questionable. As outlined in the GAO's report, I have sources here, most vehicles repaired today do not require telematics data. Essential diagnostics information is already accessible through the onboard diagnostic port or the OBD port. This raises a fundamental question. Why does Maine's law emphasize telematics access when the industry and repair stakeholders agree it's not currently essential? Furthermore, automakers in Massachusetts have disabled telematics functionality entirely to avoid litigation over similar statutory language. If Maine proceeds without addressing these ambiguities, we risk replicating these outcomes, disabling telematics systems entirely, therefore failing to deliver on the promise we made to 84% of our voters. Cybersecurity and privacy, key oversights. The Bureau of Industry and Security, BIS, and we'll just say NHTSA to save time, have repeatedly highlighted the risks inherent in telematics and connected vehicle systems. These risks include unauthorized access and data breaches. Telematics systems create multiple access points for malicious actors who could compromise vehicle control systems or exfiltrate sensitive consumer data, such as location and usage patterns, which speaks to a previous concern around DV victims. Potential for systematic failures. Poorly secured telematics platforms could enable wide-scale attacks on vehicle fleets, disrupting critical infrastructure or public safety. While federal efforts, including the Repair Act, aim to establish cybersecurity and privacy standards, Maine's law lacks comparable provisions. This absence leaves consumers and repair facilities vulnerable to the very risks federal agencies are striving to mitigate. I will note I did try to reach out to the Maine Auto Repair Coalition, but their website is now a Japanese gambling site. So I don't, maybe that speaks to the cybersecurity thing. I'm not sure. I understand domain names can lapse. So I had to go to the federal sources. Ambiguities in the role of the independent entity. The draft report proposes an advisory role for the independent entity, but needs more clarity on its necessity or added value. Current law already grants enforcement authority to the Attorney General, and manufacturers are obligated to comply with existing access provisions. Adding an independent advisory board seems redundant unless it can offer unique, tangible benefits. Moreover, the law's inclusion of a private right of action introduces further complexity. Even if the Attorney General were to issue guidance, private parties retain the ability to sue under the law, perpetuating uncertainty for manufacturers and repair facilities alike. This scenario has already played out in Massachusetts, where litigation continues to hinder the implementation of this law. Concerns from dealers and industry stakeholders. I've been very interested in some of Mr. Quirk's comments. Auto dealers have raised valid concerns about the lack of clear standards governing independent repair facilities. These include training and certification. There are no requirements ensuring that technicians accessing sensitive vehicle systems are adequately trained or certified, potentially exposing consumers to subpar repairs and inadvertently in cybersecurity risks. This speaks to some of Mr. Quirk's questions. Because this statutory language falls under both commerce and national defense, answers come from different places. My hope was to identify if it is through the OEM or federal guidance or law that the dealerships are subject to perhaps suggest a similar potential regulatory path. This is one part I have not yet fleshed out, but I haven't checked my email a bit. Ambiguous definitions. The law lacks a customary definition section and fails to define very key terms, the biggest one being independent repair facility, leaving open questions about accountability, oversight. Other definitions that are missing include, but are not limited to, standardized platform, telematics, diagnostic and repair information. This is all in the context of Maine's law. Vehicle. And you ask why? Are cars in a rental fleet included in this? I believe we probably should have included them in the conversation. Securely communicating. Vehicle owner. This is in the context of a leased vehicle. Owner authorization, same context. Mobile-based application, it's language in the statute. Reliable and acceptable systems, language in the statute. I won't go on from there. That's just a little snippet. Federal preemption and regulatory conflicts. Maine's law faces potential preemption issues, particularly as federal agencies like NHTSA and the FTC expand their oversight of vehicle data access and cybersecurity. For example, the Federal Repair Act is pending legislation, and it emphasizes standardized access platforms, privacy safeguards, and federal oversight, areas where Maine's law is vague or silent. Existing federal mandates. NHTSA has made it clear that any access to telematics must be designed with robust cybersecurity protections to prevent unauthorized system access. Maine's law lacks these essential safeguards, creating potential conflicts. Almost at the end, recommendations for moving forward. To address these significant challenges, I asked the group to consider the following before our final report is due in February. 1, this has been brought up, delay the implementation of the telematics provision, suspend section 1810.6 until a comprehensive evaluation can determine whether telematics access is genuinely necessary for repairs. 2, strengthen cybersecurity and privacy protections, which is within the charge of the group. Align Maine's law with federal standards, incorporating mandatory safeguards to protect consumer data and vehicle systems from cyber attacks. 3, reevaluate the role of the independent entity. Consider whether its proposed advisory role adds sufficient value or if existing enforcement mechanisms suffice. 4, there's only 5, don't worry. Clarify key definitions and standards. Define terms like specifically independent repair facility, and establish minimum training and certification requirements for technicians accessing sensitive vehicle systems. And 5, coordinate with federal efforts, engage with NHTSA, BIS, and FTC to ensure Maine's law complements rather than conflicts with emerging national frameworks. In conclusion, the draft report highlights the challenges in implementing Maine's right to repair law, but it stops short of addressing its foundational flaws. The IDEA Committee in the 131st established in the enabling statute for this group a report back deadline in February. This was in recognition of the complexity of the topic, charge, and significant discussions, decisions, and ideally consensus that would be undertaken. With that said, we are at a point in the time frame that will still allow the group to further evaluate comments and discussion today, research points of concern, and address them in a revised report with an additional public comment period, which has already been alluded to by Mr. Groves, I believe. The committee receiving this report, as has been mentioned today, will require clarity on what is already a complex topic, especially for new members. This includes structured, actionable recommendations that will allow for responsible and pragmatic policy evaluation and execution. Without clearer guidance, stronger protections, and alignment with federal standards, the law risks creating more problems than it solves for consumers, manufacturers, and repair facilities alike. I thank you for indulging in the time, but I did have to add to this as I was sitting back there. I look forward to continuing this discussion. I don't know if you'll have none or all questions. I just want to move on.
Well, let me thank you very much for that. Are there any questions for Representative Roberts? Anyone? I just have a question, Representative Roberts. So I'm very sensitive to your comments about the lack of transparency, because that's something that we've tried very, very hard to be transparent about. And so I wasn't quite following sort of what you were thinking was less than fully transparent.
So I know, like, for example, Representative Collmore was here and I believe had prepared comments based on what was sent out. I don't know about anybody else, but the discussion, there's been a lot of discussion since then that has alluded to shifting this draft report and language even further. And it doesn't seem to maybe be in the best, practice to do that before hearing the comment on what's there. and then maybe take the public comment and member input on what's been sent out for public comment rather than looking to change it before taking public comment, because not everyone had the luxury that I did of changing my comments on the fly.
What about the fact that we are allowing the public to comment up to, I think it's December 30th?
I think that I would probably send out another email saying that discussions were had before and that they should maybe watch them before. Because I mean, there were some very significant discussions and points of disagreement that happened in the first hour or so of today's meeting that I think are extremely relevant to the overall charge of the group and topic.
Good.
And those looking to make comment are probably interested enough to know that.
Okay, thank you. Any other questions? All right, thank you very much.
Yes, I do have one
Oh.
question, actually.
Yeah, Michael?
Yeah.
Hey, Michael.
Thank you so much, Representative Roberts.
Yeah.
It's good to see you.
You too.
You were here following our discussion about privacy and data security standards out of the Gramm-Leach-Bliley Act.
Yes.
And I was wondering if you had any specific opinions about those versus any other privacy and cybersecurity standards. Your testimony alluded to having privacy and data security standards imported from, I don't know which locations, but I wonder if
Right.
you have a thought about the gold standard and what you think of the ones in the GBLA.
Well, I mean, so Maine doesn't have we don't have a privacy law. We don't have cybersecurity. I didn't want to put stacks of paper in front of all of you, but I've done extensive research on the federal level on this. I couldn't summarize it, but it's what is the recurring theme through all of this is having those standards. Happy to if I'm happy to come back with more. Were you looking for a specific policy? I mean, I know that there are various privacy models going through states, you know, some in tandem with others, some not. I am certainly not a lawyer, but I think that any privacy policy is better than none. Sorry, Mike, I don't know if that's the answer you wanted.
No.
Okay.
That's helpful. I appreciate it. And thank you for your comments and your recommendations. Have you emailed your comments to the, I guess not, because you just edited them, right?
I did, yes, I did. Do you want our comments submitted? I know last time we didn't submit them, but
It would certainly be helpful.
I
I would love to have them.
absolutely.
That's possible.
Absolutely.
Great.
Any other questions? All right, thank you very much.
Thank you.
Is there anybody else in the room who would like to offer comments?
Mr. Tobin, members of the working group, my name is Bruce Garrity. I'm here on behalf of the Maine Automobile Dealers Association and appreciate the opportunity to make some comments in this hearing. I will say at the outset, I want to express our appreciation for the work that the group has done. I don't even know what to refer to you as. The statute says group. I sort of feel you're more like a commission, but I'm going to use group because that's the word in the resolve. And we do appreciate the work you've done. I have been at all the meetings, but for one, and I've listened to the representatives of the manufacturers, the dealers, the independent repair folks, the aftermarket parts folks, everybody. And I think they all have contributed information to your effort. That having been said, we respectfully think that you have drawn very much too much of a narrow focus on this. You're supposed to, in our view, make recommendations. They don't have to be unanimous. They don't have to be detailed recommendations, but they should fall within the scope of either the statute or the resolve. For example, under the statute, and I think this is one of the most important things that you have to do. Subsection 6 specifically refers to, and I'm quoting now, all parts, tools, software, other components necessary to complete a full repair of the vehicle, as referenced in the subsection, must be provided to motor vehicle owners and this is the key, authorized independent repair shops. You have not provided a definition of what is an authorized repair shop. And now, should that be a specific list? For example, should there be an inspection capability or licensure? Should there be concerns with disclosures, for example, under the Used Car Information Act as to prior use of the vehicle, inspectability? Should there be provisions that relate to privacy standards, not GLB per se, but the kind of privacy standards that are in that the FTC looks at, that the Consumer Finance Protection Bureau looks at? Is it a good idea for you to look at legislation that was considered by our legislature in each of the past 2 sessions relating to general privacy standards? Now, they're not law, but we had in each session 2 6-to-6 ought to pass reports from the Judiciary Committee. Now, the committee and the members of the legislature couldn't agree on which was the better one, but that's a lot of information that you could consider to say, well, we think 2 or 3 of these might be standards to consider. You don't have to say this is what you should do, but this is what you should consider. You heard from a broad array of people on a variety of topics that you might say, here are some things for the committee or the legislature to consider, because that's who you're reporting to. You're not reporting to an independent entity, but to the legislature. Should a poster be required in a repair facility saying, we're not authorized by a manufacturer? I'm not going to use it, but I brought in the poster that's required by law today that says you got to post your prices, among other things, that every repair facility has to have in its shop. Should that be amended? I don't know. You might say, simply consider that, members of the committee, not you have to say do it or don't do it. Should there be a notice on an invoice? Should you say there's no warranty protection associated with the work of an independent? And that would apply to a dealer who's working outside the scope of their franchise as well. Should there be a notice that the work that's being performed isn't from a certified, a manufacturer certified mechanic? I was reminded specifically the testimony from the gentleman from Auto Works, who went into great detail on some of those things. And that dovetails into what should the uniform tool be? What should the uniform tools be that are available to anybody? Cybersecurity issues. I mentioned that you have, not only do you have the statutes that have been considered, you have, for example, the independent privacy statute that has been enacted in the insurance code. Is there anything that could be applicable? I don't know. You have the red flags rule under Gramm-Leach-Bliley. The concept being you better know who you are working with. That's the concept. Is that a good idea? There are protections that that GLB puts in place for privacy, and in particular, maintaining records as private. You can't just leave information lying out on your service counter so that after person A comes up, person B can come up and look at that kind of thing. You don't have to say that's a good or bad idea necessarily, but we respectfully suggest you say, this is a point for you to consider, members of the committee, and here's some of the things different people have said, something like that. Should you specifically reference safety concerns and simply say, NHTSA had a number of comments to the Massachusetts folks, and we think you should look at the NHTSA letters as it relates to safety. You don't have to say NHTSA's right, NHTSA's wrong. I guess along with what is the material that's going to be required, should there be any kind of registration or licensing requirement? And I'll give you a perfect example.
Mr. Gary,
and I am
let me just say
done.
that you're just at 5 minutes now,
Yeah.
so if you could just
I have
wrap
30
up.
seconds left, and that's all, Mr. Top, except for the 10 seconds I just made an excuse. Dealers have inspection licenses. Should an authorized repair facility also have a inspection license, because then you know what you're doing in terms of whether the car is inspectable for anybody. With that, we do appreciate the work you've done. We would echo some of the comments that we've heard that Mr. Quirk made and some of the comments that Representative Roberts made. And I'd be happy to try and answer any questions should the group have any.
Great, thank you very much. Are there questions for Mr. Garrity? All right, seeing none,
Thank
thank
you.
you very much. Is there anybody else in the room who would like to provide comments?
Mr. Taub and members of the working group. My name is Bill Bell. I'm here on behalf of the Maine Auto Recyclers Association, which is a standard 501c6 trade association consisting of the 300 or so licensed recycler firms in Maine, of which most are mom and pop operations. The larger ones are virtually all members of our association. The first hour of your discussion reminds me of my first former life when I was in the State Department's Intelligence Bureau, and the intelligence community in Washington prepares a national intelligence estimate on any given country. And the different agencies, CIA and Defense Intelligence, State Department, they have to get together and write this. When the product comes out, the first thing people turn to are the footnotes of disagreement, because that's where they feel the meat is. And anyway, that's what you heard the first hour. We strongly commend and support the work of this working group, where you have arrived at a number of very valid and very important agreements. I stopped off today on my way up. If you get off the Gardner exit, you go by Brown's Auto Recycling. And the owner of that is the most immediate past president of our organization. And he said, good, I told him that you are not creating a well-funded, powerful bureaucracy. And he said, no, I believe in small government, but he also believes in your unanimous recommendations. So I will not comment further, except that we support the work with regard to the unanimous recommendations. Now getting into the disagreements, I'll keep it brief. We are not in support of the recommendation to postpone everything for a year. I think the fact that we got to this point is because of the objections that were raised by the same people who are objecting to progress at this point. And the delay is something that they will, or the lack of synchronicity between when your report is due and when the rule goes into effect, they cause the problem and let them deal with it. We want to commend Brian for having raised the issue of the heavy-duty vehicles. And we do not agree. In fact, we strenuously disagree with the solution being to exclude them from the coverage of the law. And we support the action which you took at your last meeting to add a representative of manufacturing of heavy-duty vehicles and to add a representative of the independent repair facilities to the independent entity, or the, I guess to be called, Commission on Right to Repair that you're recommending. And went over, there's only one major recycling firm dealing with heavy duty vehicles, but it's right behind you, about 5 miles out into eastern Augusta, White and Bradstreet truck repair. And it is huge. I mean, it's acres and acres and acres of vehicles. And Maine's a trucking state. Almost everything that comes in and out of Maine is via truck. And these vehicles need to be repaired, and White and Bradstreet dismantles vehicles and takes the parts out and also repairs them. And so they need, as do the other garages that repair trucks in Maine, they need the same access to the data in the manners that you all have been discussing. And so I think it's very important that.
So I'm just gonna say you're right at 5 minutes, a little over 5 minutes
Oh,
now,
okay.
so.
Okay, well, it's just very important that you keep this, what was, I think, a unanimous agreement to include these, include heavy-duty vehicles in your recommendations. And that
Great.
concludes my testimony, unless there are questions.
Well, thank you very much for your testimony. Are there any questions? Thank you very much.
Good afternoon, members of the working group. My name is Dan Riley. I'm an attorney with the firm of Norman Hanson Detroit here in Maine, and I'm here today on behalf of our client, the Truck and Engine Manufacturers Association. I'll just really point out one area where your draft report and your draft recommended red line don't match up in our view. And that is that your report does not reference the fact that, for obvious reasons, you didn't have time as a working group to take up the issue of medium and heavy duty vehicles and their repair cycle, the sales of those vehicles, et cetera, and how those compare with the consumer automobile market that you spent so much time on. So our request would be, and you discussed this in the last meeting that you had, our request would be that in your report, where you describe the working group meetings, and you've got one section that does that, right at the end, if you would just reference the fact that you did not have time to take up that industry and how that might differ, that would be, I think, of use to the legislative committee in particular that's going to be looking at this issue. And that's, as Mr. Boggs said at the last meeting, that's really just to be transparent. And we don't complain that you didn't have time. Obviously, you had a lot to deal with, but the report does not reflect that. And yet, the way that you have attempted to deal with that is that in your red line recommendations for amending the statute, you have included, as Mr. Bell just referenced, adding a representative of the medium and heavy duty manufacturing industry and a representative of the repair industry that deals with that market. So in that way, your red line recommendations make it appear as if you took up something that you did not have time to take up. And that's not, as I said, it's not a complaint. I think the majority of you recognize that you, as was the legislature previously, were presented with a very difficult situation.
you have a statute that is Maine law that was created and passed by initiated referenda that essentially exports from the Commonwealth of Massachusetts a law that was passed down there by initiated referenda. But there is absolutely no definition section in that initiated legislation or now the statute. And as an attorney who focuses on legislative law, section 1 of every single chapter of Maine law is the definition section. And the people that work down the hall in the Office of Policy and Legal Analysis will ensure that is the case before they will ever allow a piece of legislation to be released from a committee of jurisdiction. But because of the citizen-initiated process, that doesn't happen. So you've got a current law does not define many of these terms that are really complicated. And that made it very difficult for the committee of jurisdiction last session. It will make it difficult for them again this section. I recognize that not all the members of this working group are going to agree that the underlying statute is as poorly drafted as it is, but I think many of you have recognized that over the course of this process. So I'm just going to give you 2 examples of why, had you had the time to take this up, you would have seen a distinction. Number 1, in the medium and heavy duty vehicle market, the vast majority of transactions are business to business transactions. They're not regular consumer going into a dealership and buying a vehicle. So that's number 1. And that complicates the whole right to repair situation in and of itself. The other distinction that's really, really important is that the medium and heavy duty vehicle market is not a vertically integrated marketplace. I'll give you one example just for time.
And you are right at 5 minutes, just to let you know,
So
Mr. Riley.
Cummins diesel engines are utilized in many of the major manufacturers of medium and heavy duty vehicles. I see Mr. Quirk nodding his head because he knows that. Well, you got an engine that's manufactured by Cummins and a vehicle that's got a Ford or a Volvo or a Caterpillar or whatever name it might have on it. How is that going to work in the context of this right to repair scenario? So with that, I will close my comments and be happy to answer any questions that you might have.
I think Mr. Groves has a question.
Is it Mr. Riley?
Yes.
Thank you very much for your comments today. I appreciate it. You've raised some, I think, some very interesting points and issues. I'd like to explore just for a moment with you. I assume that you're familiar with the memorandum that was sent to this working group from Patricia Hans, dated today, December 19th, 2024.
She's my client.
Yeah, and I think it was provided to the working group today. But there's a sentence in the conclusions and recommendations section. I don't know if you have that in front of you, but I could just read it for you. It's just one sentence. It says, "We note that the Automotive Right to Repair Working Group has specifically excluded any members of the commercial vehicle industry despite EMA's request, since its original focus was to be solely on passenger vehicles." I did miss the first meeting of the working group, and perhaps there was some request from EMA that came then, but I'm not aware of any request that has been excluded. And so I wanted to explore that statement with you to find out what the genesis of that was and what specific requests have been made so that I can understand, because I don't think it's the intent of the working group to have excluded anyone.
No, and I think what Ms. Hans was referring to is that the resolve that directed this working group to be created only had certain manufacturing representatives on it, a certain number of manufacturing representatives on it. So you had 2. You had Mr. Boggs from Tesla, who obviously was an expert in his area, and then you had Ms. Frazier's group. So I made a request when the Attorney General's office was trying to appoint people find people like yourself to serve on the working group. We will find somebody in the state of Maine to serve on the working group should you need someone. And so Mr. Taub said he would, certainly consider that, but that this group was focused on the automotive sector. And so that's why you ended up with, Mr. Quirk and the Alliance and Mr. Boggs. So as I said, there's no complaint that you didn't have time to take up this particular issue. It's just that you did not have anybody serving on the working group that represented this sector. And yet your recommendations in the red line make it appear as if you did take that issue up.
Yeah, I appreciate that very much. And I don't know that I agree with your repeated comments that the group hasn't had time to take up those items, be that as it may. I just wanted to make sure that there was no specific request that came to the working group as a body that you felt was ignored by your client.
No, this was the first opportunity that was provided for a public hearing on this particular issue. The previous public hearing that you had was just about the independent entity. And so that's the distinction, I think. There was a representative from one of the members of EMA who did testify remotely at that hearing on the independent entity piece, but that was a very specific issue. This is the broader, so this is the first opportunity that I felt it was appropriate, and Ms. Hans felt it appropriate to submit written comments.
I appreciate your clarification. Thank you.
Any other questions for Mr. Riley?
Chris, I was just when I shook my head, I've seen vehicles come in with a Eaton rear end, an Allison transmission, and a Cummins engine. Yeah. And I don't know how the heck they're going to be able to put that all together. And I just want to add that the way vehicles are made today, a lot of vehicles have engines that are made in Korea, Russia. And it'll be very interesting how these manufacturers are going to be able to take all these different entities. It's no longer a Ford engine or a GM something. There's many facets in the automobile industry where they come from all over the world. And it's going to be very interesting.
Any other questions for Mr. Riley?
I have a question, and it builds off of Jack's comment. In this world for heavy duty, medium duty vehicles where the engine comes from one manufacturer, the rear end from another, a chassis from another manufacturer, and that most sales are these business to business sales where the vehicles are custom built, built to spec by the specific customer's recommendation and specifications by a final vehicle integrator. Mr. Riley, how do you interpret Section 6 as to who does it apply to? Is it the telematics systems by the engine manufacturer, or by the chassis manufacturer, or by the vehicle integrator, or by the final entity that sold the vehicle, or by the later aftermarket telematics system that are used for fleet management? So I'm curious to hear your thoughts on, as representing your client, how would you interpret, to whom does Section 6 apply?
Ms. Boggs, all I can tell you is that I've had multiple conference calls with my client and the client's legislative committee, which includes a variety of different manufacturers. And their questions to me are the same questions that you have posed, and I cannot answer that question, in large part because I can't refer back to a Section 1 of the underlying statute that defines all of these different terms. And the way that the statute, the current statute that you've had to deal with, is drafted, it utilizes multiple terms that are defined in other main laws, and it uses them interchangeably. And so you've got motor vehicle as a term that's not defined. you've got commercial vehicles, you got heavy duty vehicles. All of those are utilized within the citizen initiated law. Obviously, you can refer back to other sections of Maine law, but that's not how it generally works in a chapter of Maine law. Normally, you've got definitions, and I won't belabor the point that Representative Roberts made very well, but that's the problem. Is it just from a drafting perspective, you can't take Massachusetts law and just plug it into Maine law. It doesn't work that way. I wasn't around back then, but maybe that goes back to the reason that Maine seceded from the Commonwealth a while back. But anyway, it doesn't work, and so as an attorney, it's very difficult to advise my clients about the applicability of these different sections.
I think that's a very important point. When I compare the definitions that exist in other statutes in Maine versus Massachusetts, for the core aspect of the statute around what is a motor vehicle, there's some key distinctions. In Maine, the limited definition describes a self-propelled vehicle designed primarily to transport fewer than X number of people. I think it was 14 people. So, but in Massachusetts, it has some additional clarifications that that these vehicles, they're talking about the ones that are designed and used primarily for use on public streets and roads and highways. So without that clarification, it's actually unclear to me to what extent are we talking about motor vehicles. And this was represented in the handout as well from, I think, the motorcycle group here. Looking at that definition, I actually don't know, or is the scope of this statute now extending to scooters and electric bikes and any other propelled vehicle and logging equipment, and because the definition actually doesn't say anything about used on public roads. So I share your concern, Mr. Riley, that without some clear definitions, the scope of what we're talking about is either super, super broad or totally undefined.
Brian, is there a question in there somewhere?
Sorry about that. Yes.
You say, isn't that right?
Isn't that right? Do you agree with that? Sorry.
I think Eric has a question.
Yeah, I'm just trying to understand. I mean, independent shops today are working on trucks with components from different manufacturers successfully today, right?
Are you asking me whether that?
Yeah, I'm asking you today.
World?
Independent shops are working on heavy duty vehicles today. It made it sound very confusing that different components and different manufacturers and here's all the reasons why it's tough. But aren't independent repair shops today in heavy duty working on vehicles that have multiple components from different manufacturers, and they're doing it successfully today?
Well, you didn't have an opportunity to take that up in your deliberations because it is a different. Let me finish. It is a different process and a completely different system by which medium and heavy duty vehicles are repaired. Much of the repair is done by the owner of the vehicle, whether it's a municipality or whether it's a trucking company or whether it's a construction firm. And so the differences between the passenger automobile marketplace that you spent a lot of time on and got a lot of presentations about, and the medium and heavy duty vehicle marketplace are very, very, very distinct.
Understood. Can you, yes or no, are independent repair shops today in heavy duty working on components with multiple manufacturers?
This isn't a cross-examination, sir. So
I just want to yes or no. Yes or no. The answer is yes, they are. So the question is, how do they do that? And how do we preserve their ability to do that? That's what this law is about. Thank you.
Good question.
I mean, I think the question is, do you know whether or not independent repair shops are currently working on heavy duty vehicles?
I believe there are some, yes.
Okay. Any other questions for Mr. Riley? Yeah, Elizabeth.
Yeah, I just wanted to echo that I think what you've raised is appropriate with respect to inclusion in the report about how this was a distinct area, both, you know, sort of technically and legally, that we weren't able to get to, and that is something that should be called out in the report. And isn't that so?
Yes, and I think it would be different if the red line amendment didn't specifically include reference to the industry, both on the repair side and the manufacturing side, where the report doesn't discuss it in any way, shape, or form. So that's where the lack of transparency is from our perspective. And
I should just say, from my this is like totally personal to me. When I having agreed that we should talk about including someone in heavy duty, right? I was with the group that said, hey, we should include a recommendation that someone with heavy duty manufacturers is in the final advisory committee. I can even concede how, as an outside viewer, I would see that as the group having done something more around heavy duty vehicles than we did. And you're saying that's your
correct.
reading.
That's the concern of the association.
I just want to say I was trying to help you, but I think I might have hurt you.
No,
when it came to
I
that recommendation.
appreciate your comments, Mr. Quirk. Thank you.
Any other questions for Mr. Riley?
Thank you very much.
All right, thank you. Anyone else in the room who has comments for the group? All right, seeing none, I'm going to ask anyone who's participating by Zoom to raise their electronic hand. And then I think, Katrina, you'll bring them in one by one.
People do need to accept the little request though.
Yeah, in case you can't hear Katrina, you're going to get a request to accept from her. And so you need to accept that in order to have you travel through the wormhole to us.
And then don't panic when Zoom quits on you. You will come back.
All right, looks like Mr. Tanner.
Yes. Hello, everyone. Mike Tanner. I am the Director of Vehicle Technology and Innovation with the Auto Care Association. I first of all, I want to point out that remote diagnostics as a business case, I think if you all saw the video from BMW and that using that business case, and I think that that will be the future, the ability to diagnose vehicles remotely and then direct the vehicle owner to their facilities is a big advantage over the aftermarket. Not only is that create efficiencies, but it creates conveniences for the vehicle owners and ability to schedule and to order parts. So the fact that I just want to point out that is a valid business case, and that could be a key advantage. I also want to point out something that we tend to lose perspective on. CPUs, networks, data storage, data management, remote access to vehicle or to data. Just because we put that on a vehicle doesn't mean that we have to start over from scratch on how we manage that, how we secure that, how we control access to that. Those same capabilities exist on a cell phone, for instance. Those are mobile. The ability for phone users to control access to the data on their phones is typical today. On a per request basis, you can allow or disallow access to that data. I would argue that just because it's on a car, that technology changes in any way. It can be done, and it should be. The vehicle owner should have the ability to control that access to that data. And I think the privacy issue exists on the phone. I think the phone is more private than obviously the vehicle would probably be secondary to that. I think the real concern is the safety issue here. And that has been looked at for the last at least 10 or 15 years. You guys had seen some information on some standards. ISO 21177 is the intelligent transportation system. It creates the security surrounding all of the infrastructure in the intelligent transportation system. Because of the sensitivity to safety, and it was also done in regard to the stringent EU GDPR requirements. It took into account the privacy aspects of that, and it does establish that type of security. We also talked about SOVD, which was created by Vehicle Manufacturers Association, that provides similar type of a security framework, more specifically granular data management, which allows the data to be segmented and delineated so that only diagnostic data is accessed. And I think one also that I think Mr. Boggs is familiar with would be the Trust Authentication SAE PKI 001, which secured the charging infrastructure that provides a very robust security infrastructure that allows for authentication and authorization of access. All of these, or any one of these, can provide the necessary security to do this. I would argue that technology is not the barrier here. I think it could be the springboard. I think what's missing is definitions of policy that can be implemented by these technologies, and the policies need to be established through stakeholders. And I think the policies could help alleviate the subjectivity that I think Mr. Boggs has pointed out through a determination of the rules for how and what data is accessed. And that's all I have to say.
Thank you very much. Are there any questions for Mr. Tanner? All right, seeing none, I want to thank you again, and we'll bring in the next person. Okay. Do we have someone that's been brought in, maybe who's not on camera? Dan?
Looks like he's on mute.
Yeah, can you hear me?
Yes, we can't see you, but we can hear you.
Perfect. Yeah, I'm not in a spot I can be on camera here, but thank you for giving me the opportunity to speak here. My name is Dan Ninus. I'm the Chief Operating Officer with a company called Diesel Laptops. We are a US-based diagnostic tools and repair solutions company that works specifically with the aftermarket. Our basis for our company is heavily invested in both medium and heavy duty commercial trucks, also in the off-highway market, and we do work our way into the automotive sector as well. So I came in today specifically to just make some commentary and also perhaps make myself available for some follow-up questions or even some offline discussion. But my specific topic that I wanted to address today was about the medium and heavy duty truck segment. And based on the previous conversations and some stuff that I've had the opportunity to review, both from Mr. Boggs, who's present today, and there was a representative from Daimler Trucks North America, I believe his last name was Tring. They had some commentary that kind of went along with what the previous speakers today, Mr. Bell and Riley, were talking about, where it at least kind of alluded to perhaps the exclusion of the medium and heavy duty segments going forward with this Right to Repair Act in the state. And I wanted to maybe clarify, if possible, about some of the vertical integration issues that have been brought up. I would 100% agree that on the manufacturing side, that the vertical integration in the heavy truck market is completely different than automotive. Some of the automotive practices are actually moving that direction with bringing in some outside suppliers. But once the vehicle's assembled, there are standards in place for communication and how the diagnostic systems have to run. All of those information systems are reporting back through common modules and available through the diagnostic port that's been mandated on all these vehicles going back for 20 years plus. So my company actually currently supplies both tools, repair information, wiring diagrams. We've built a full training platform, both online and in person. We've got training locations, brick and mortar, at 3 different sites across the United States. So we've been working on this exact issue for many years already. We're about to have our 10th anniversary in March. And my background in the industry was over 22 years working in the repair side of it, specifically in the OEM dealerships. And all of that time was spent within the Daimler Truck North American network. So I've got some pretty close ties to some of the things that were said, a deep understanding of what these issues are and what the problems are. And the company I work for today has been addressing these with solutions based, in multiple different facets for many years. So the vertical integration piece, not such an issue that it might seem, as far as how would we make this happen going forward. We're already doing it. But with the data that's being reported by the vehicles and available specifically with conversation to the maintenance and repair of the vehicle, about 90% of that data is already publicly available. So if you've got a tool that's readily available, you can actually read that data. There's about another 10% that is held as proprietary information. Some of that goes directly aligned with what Mr. Boggs is speaking about, and I wholeheartedly agree about some of the safety concerns and things about maybe the remote capabilities for sending bidirectional commands. But really what's holding back, and I think what a lot of the voters here and across the country are voting for, is the right to access that data for the repair and maintenance side of it. I don't know that everybody wants to have, information about where the vehicle is and how it's being used. But when it comes specific to the repair and maintenance of the vehicle and the way that the business-to-business transactions work and the way that fleets operate and have their own maintenance facilities across the country, it's just vital that we get some of that stuff unlocked for these guys so that they have the ability to service these vehicles in the future. The genesis of what I do kind of comes from the fact that the manufacturers and the supporting dealer networks don't have the capability with the number of technicians, open bays, hours of service to keep up with all of the vehicles that they're producing annually, and the fact that they have to maintain these vehicles for many, many years. Commercial vehicles have a much longer life cycle in most cases than the automotive passenger counterparts do, and they rack up a lot more miles. So they do need a lot more care and a lot more maintenance. And the thought that those vehicles could all make it into a dealership is frankly ludicrous. The cycle of these vehicles, while they're new and they're still within their warranty period, most of those repairs are going to be done within the dealer network because they're paid for there. Once they fall outside of that warranty period, though, they're left to aftermarket for the most part, and there's just a lack there of available information. So we've been trying to make that available for, like I said, for 10 plus years. We do a great job with it. We've got well over 100,000 unique customers based here in North America. We provide them with not only free software and free diagnostic capabilities, but we also have many tools that are highly functional in the range of $350 or less that give them some of these capabilities. So I just want to give the opportunity to anyone who might want to ask any questions, might be able to help with, or like I said, make myself available to this panel for some offline discussions, both myself and some other counterparts from my company that might have some very useful information for this topic.
Great. Thank you very much. Are there any questions for Mr. Ninus? All right. Seeing none, thank you very much. We'll now bring in, is there anyone else to bring in? 2 more.
Yay, me. Hi, good afternoon. My name is Kristen Kellogg. I am the Senior Director of Government Affairs for Commercial Vehicle Solutions Network, or CVSN. I'd like to read my prepared statement, and then I really enjoyed this conversation and hearing some other testimonies, so I have a couple of comments I would like to make on that as well. CVSN represents a wide range of professionals in the aftermarket service and repair industry, including independent repair shops, parts distributors, and service providers who support commercial vehicle owners and operators nationwide. We have been closely tracking the progress of this legislation and understand that manufacturers continue to oppose the inclusion of commercial vehicles. We are here to reaffirm our support for the inclusion of commercial vehicles with a gross vehicle weight, or GVW, over 14,000 pounds in Maine's right to repair law. Commercial vehicles include delivery vans, box trucks, dump trucks, trash trucks, all the way up to Class 8 large trucks. We are pleased to note that this law aligns with the clear will of the Maine voters, who overwhelmingly expressed their support for this measure with 84% of the vote. This widespread backing reflects a strong demand from both business owners and consumers for more access to vital repair data, which is essential for maintaining and servicing commercial vehicles in the state. One of the most pressing concerns in the commercial vehicle industry today, and this actually mirrors just what Dan just said, some of this is a little redundant, today is delay in repairs due to limited access to necessary diagnostic and repair information. Commercial vehicles are the backbone of many industries in Maine and throughout the United States. And when these vehicles are out of service, it can cause disruptions that ripple through supply chains, negatively impacting businesses and consumers. By allowing greater access to onboard diagnostic and repair information systems, this law will facilitate faster repairs. This will ultimately enhance operational efficiencies and minimize delays in delivery, benefiting the broader economy. Commercial vehicle owners should have direct access to their repair information, empowering them to decide where and when to service their vehicles or trucks. Currently, dealerships have exclusive access to the most up-to-date diagnostic tools and repair data, creating an imbalance between dealership service departments and independent repair shops. This limits consumer choice and makes it harder for small businesses and independent fleet owners to maintain their vehicles efficiently. By ensuring that owners can access essential telematics data, this law fosters a more competitive environment, allowing independent shops to offer the same level of service as dealerships, ultimately benefiting consumers with lower costs and improved service quality. Commercial vehicles are equipped with crucial safety mechanisms that require regular maintenance to ensure they remain operational and safe on the road. However, without adequate access to repair information, these vital systems may suffer from delays or incomplete repairs, putting both the vehicle and its driver at risk. Currently, limited access to repair data often forces consumers to rely on authorized dealerships, which again can be costly and time-consuming. By ensuring access to telematics systems and onboard diagnostic information, this law gives consumers more repair options, including trusted independent mechanics and shops. This promotes not only better access to timely and affordable repairs, but also ensures that safety systems are properly maintained, protecting both the vehicle and the people who depend on them. In conclusion, this law is an essential measure that will address a critical gap in the maintenance and repair ecosystem for commercial vehicles over 15,000 pounds, which does include medium duty and up from there. By ensuring that onboard diagnostic and repair information system data is accessible, we will see faster repairs, increased consumer choice, improved service quality, and greater parity between dealerships and independent repair shops. Furthermore, it will help alleviate supply chain concerns and contribute to a more efficient economy, benefiting both businesses and consumers in Maine. With the overwhelming support of Maine voters, this legislation represents a significant step forward, and we strongly urge its elected officials and the subsequent working group to continue to uphold the will of the voter. Thank you. Any questions?
Thank you very much. Any questions for Ms. Kellogg? All right, I don't see any. Thank you very much again for your comments. They were very helpful.
Thank you.
All right, I think we have one more person to bring in.
Hello.
Yes, go ahead, and if you could introduce yourself and then present your comments.
Thank you. I'm Brian Romansky. I'm a technical advisor representing the Auto Care Association. I'd like to provide a brief clarification of a statement that I made during a previous session, a statement that was referenced by Mr. Boggs in his written comments sent to the committee, and it's related to some of the prior discussion about higher risk commands that can be sent to a vehicle via a telematic system. In that prior meeting, I was asked if some higher risk commands could be disabled during a remote telematic repair session, and I agreed that yes, some commands may be disabled. The intent of that statement is that manufacturers would not have to remove any safeguards or protections that are currently in place in order to comply with the law. My understanding is that such protections would be applied uniformly, regardless of who is accessing the vehicle via telematics, and not be applied selectively. I'd also like to comment briefly on Representative Roberts. She presented in her remarks a list of cybersecurity risks associated with telematic systems. My note is that those risks exist today by the mere fact that telematics is already in use. The risk of wide-scale attacks via telematics, it's independent of whether those telematics are being used by the manufacturer, dealerships, or vehicle owners. So it's something we've already accepted as a community. Those are my comments. Thank you.
Great. Thank you very much. Any questions for Mr. Romansky? All right. Seeing none. Thank you again. All right. And if there's anyone else on Zoom who wants to address the group, raise your electronic hand. Nobody else? All right. I will close the public hearing portion then. So I think it probably makes sense to discuss a little bit about what our next steps are going to be. A couple thoughts I had is that one, we've heard some suggestions during the public hearing of additional things that should be in the report. So I think we probably all want to have some time to reflect on that. We also have decided that we're going to give an opportunity to members of the group to provide any sort of additional recommendations or considerations that they want to include in that final section of the report. I think Brian and I, we're going to try to maybe come up with some language that might work for that section 6 portion that we were talking about earlier. And so I don't know. Well, so I guess what I'm thinking is whether we want to have some period of time between now and our next meeting where people would send to Christina and me any additional recommendations or considerations that they want to have included. Brian and I can endeavor to circulate some language. And then I don't know if people might also, and again, I'm just brainstorming. So if these ideas don't work, just say something, but I'm wondering if there are things that people want to include or change in the report based on what they heard during the public comment section, maybe they also should send that to Christina and me so that we could include it as a proposal in the next version of the report. And then my thought is that at the next meeting, we could sort of review everything that we've circulated already. We could also discuss, if people want to have a discussion about what we heard during the public hearing and have a discussion about the extent to which any of those comments should get incorporated into our report, we could have that discussion as well. And then I guess we'd have to, I think we'd have to have at least one more meeting after that one to hopefully finalize the report and the statute. So let me stop there and just see if anyone thinks something like that might remotely be feasible or work, or see what people's thoughts are about that. Great. Okay. Is there anyone who has concerns about, and I know we need to talk about timeframes, but just in terms of sort of the concept, is there anyone who has any objection or concerns about that approach? Okay.
No objection.
So in terms of maybe just working backwards a little bit. I think we're in pretty good shape time wise. We don't have to submit the report until the end of February. I don't want to leave it to the last minute just because things always happen at the last minute that you're not expecting. But I guess I'm wondering whether we want to make our next meeting like maybe the week of January 13th. maybe like either the end of that week or the beginning of the next week, the week of the 13th. Do folks feel okay about that week generally? And what we'll do is I'll send out an email asking people for their availability or for any conflicts that they have with the week of the 13th. And if you could just send me your conflicts, we'll just do our best to schedule it during that week. So does that time frame work?
Is it any time that week?
Yeah.
Let us know
Yeah.
what conflicts we have.
Yeah. And I'll send an email out just
Okay.
so people remember.
Yeah,
But
that's
yeah, just respond, maybe like by Tuesday or so if you can.
Can I just one point there?
Yeah, sure.
The only thing that would interfere that I can think of is committee schedules aren't out yet.
Right.
Nor do I think we should wait for them to come out because, it'll be haphazard, but that's just.
Well, and that's a good point, and we might lose our ability to use this room
Oh, yeah,
also.
I didn't think of that. But
Yeah, so that's a great point. And so Katrina and I will have to figure that out if we can still find a room to use or not. What's that?
Meet at your house.
Yeah, sure. You can all come to my house. Yeah, absolutely.
Chris, could you restate what dates you were thinking of? I didn't quite hear.
Yeah, so we're thinking sometime during the week of January 13th. And what we'll do is I'll ask people by email to send me any conflicts they have that week. Okay, and then we need a deadline. So we need a deadline where people would send us either additional recommendations or considerations or things that they think should be included given what we heard at the public comment. So Christina and I would need to get that. We would need then to incorporate those into a revised report and then circulate it to the group and then give the group enough time before the meeting to discuss them. So what I'm wondering is if we set a deadline of maybe, and we can monkey a little bit around with it depending on whether like we're meeting on January 13th or January 17th. But I'm wondering if maybe like January 6th would be an appropriate deadline for people to get Christina and me any additional items that they want to see included. Does that sound doable? Okay. And then Christina and I will shoot to get something out to folks at least a few days before the meeting on the week of the 13th. You seem concerned, Jack. Are you?
Thinking of my next thing. I guess.
So, and we can put this in, I mean, we'll put this in an email, obviously, but it sounds like where we are is like, we're going to shoot for a deadline of January 6th for people to submit stuff to Christina and me. We'll turn that stuff around within a few days, get it back out to the group, and then we'll have our next meeting the week of the 13th. And then what I'm hoping in that meeting is we'll reach a final consensus on what the report and the statute should look like. Christina and I will do a final version, and then we'll have like one last meeting, which I'm hoping would just be like sort of like a language review meeting. It would just be like, here's what we have now. Is everyone okay with this? Hopefully everyone will be okay with it. We can formally vote to adopt it. And then I think the work will be done. Does that approach make sense? Okay. All right. I think we're adjourned for today. So thank you very much, everyone. Thank you.
Thank you. Merry Christmas. Happy holidays. Happy Hanukkah.
There might
All the above.
some fertile ground on